Okay. Okay, thank you. I'm going to call the case People versus Hurley. This is a mini oral argument on the application, 15-minute argument per side. Mr. Habel, I think what I will do is see if anybody has questions, and if the court does not, then we will submit the case on the briefs. Does anyone have questions?
I guess I could. Well, did you want to close?
What was that?
I do have a little bit of something prepared. If the court would be willing to hear it, I can keep it short.
Okay, sure. Does anyone have any questions before that, or go ahead?
Your Honors, this is a 606B case. All the way up through the courts, it's been 606B, it still is. And the question that was presented to the trial court is whether or not a juror's prior experiences were an outside influence. And the trial court answered that wrong and said, yes, these previous experiences are an outside influence. The Court of Appeals disagreed and said, it's quite clear from the case law that a juror's previous experiences, any of a juror's previous experiences, are not outside influences. Those are internal influences. Every juror comes in with a history, with a background, with good ideas, with bad ideas. It's part of the fact that we're human. But those that come in with the juror are internal influences. And 606B applies.
Isn't 606 for deliberations?
606B.
And this is pre-deliberation?
That's actually a great question. 606B has 2 points. 606B says, no member of the jury may impeach a verdict based on anything that happens in the jury room, thus the deliberations, or anything influencing any juror to assent or dissent from the verdict. So anything that influences the juror or anything that happens in the jury room. In fact, Budson goes on and is very clear. It's not a matter of whether this occurs inside the jury room or whether it occurs outside the jury room, but rather it's from whether the influence is from within the jury or something coming in from the outside. We don't have anything coming in from the outside. And accordingly,
Counsel, can I ask a
yes.
question? First off, you have the nicest demeanor. I just have to say, it's very peaceful, just a very nice demeanor. So it's a pleasure to have you with us today.
Thank you, sir.
Like I say, this is a little bit like a one-horse race. So I don't know if that's good or bad. Sometimes there's more pressure in a one-horse race. But the question I'm going to ask is really this: is the person, they did independent outside research, did they not?
They did not. That was confirmed at the hearing. No outside research was done at all in this case.
My understanding was that they had cited the materials saying that there was a percentage that was cited that said the 70 percentile.
That was the initial briefing to the trial court. That's the whole reason why we had the hearing in the first place.
Right.
And quite frankly, there is precedent that outside research is not allowed. But
Right.
when they put the juror, TM, on the stand, in fact, first when they put NB on the stand, the defense juror, and they asked her, did this other juror do outside research? She said, no, I don't believe she did outside research. I just think she was talking about her prior experiences. Then, when the court put NB on the stand, TM on the stand, and TM's the juror who is accused of raising that.
Right.
She said, I don't remember using a statistic, but I just shared my experience that about most of the men I knew from my job working at a factory.
But the jury didn't hear, the jury heard just the first part, right? The 70%.
The jury heard none of it. Okay,
Well,
excuse me.
no.
My
The
bad.
jury heard
The jury heard.
The jury heard the claim, right,
Yes.
of the 70%.
In-
They didn't hear the explanation that actually, I didn't do research. Actually, that's just based on my own experience, based on all of this, which would have been helpful, correct, to actually properly consider that information?
The record is not clear. She was never asked about that. And in fact, she said she didn't remember that statistic, but she said she wouldn't disagree with it. And she did clarify, according to my understanding of the hearing transcript, she did clarify that, well, yes, it was based on my impressions, and she never represented otherwise to the jury. In fact, if she had represented otherwise to the jury, then NB would have said that. NB would have said she did outside research. But when NB was on the stand, she said, no, I believe that was just from her personal experience. So the jurors knew that she was just spouting off her impression.
But wasn't that done for a purpose?
Well,
And did it not have any kind of influence or impact on the others?
I don't think this had any impact whatsoever. But if I can throw this out there, Your Honor, it doesn't matter. Because that 606B is crystal clear. If it is an internal thing, even if it's wrong, if she had gotten up, way wrong, if she had said, I think that 70% of people accused of crimes are aliens. Like, from a different country. No, from outer space. It doesn't matter, because internal influences are allowed. If we get to a point where we are going after a juror's internal influences and their prior experiences, then the jury is going to be litigated nonstop. All you have to do is get one juror to say, I had a weird prior experience that causes me to question my decision. New trial. I think this juror over there had a weird prior experience. New trial. And this warning doesn't come from me. This warning comes from McDonald v. Pless, which was the Supreme Court 108 years ago, back in 1915, when they said, hold on here. Can I read a quote from that? In McDonald, the court explained the problem eloquently. If jury verdicts were open to impeachment by jurors, then, and I quote, jurors would be harassed and beset by the defeated party in an effort to secure from them evidence of facts which might establish misconduct sufficient to set aside a verdict. If evidence thus secured could be thus used, the result would be to make what was intended to be a private deliberation the constant subject of public investigation, to the destruction of all frankness and freedom of discussion and conference. And the McDonald court went on, and they used a snippet that has been repeated again and again and again throughout the ages in the Supreme Court, in the federal courts. And that snippet is, the McDonald court agreed that, some verdicts may be overturned due to bad juror behavior if we allowed in this type of testimony. But that, and I quote, it is not at all clear, however, that the jury system could survive such efforts to perfect it. So, Your Honors, I would submit to you that we have a good rule of evidence in 606B. I would submit to you that it has withstood the test of time. In fact, you can trace its roots not just back to Pless 108 years ago, you can trace its roots back to England in 1785. And I believe that that rule should be upheld in this case.
Counsel, I'm wondering, one of the things I find challenging in this case is judges do not grant new trials lightly. It's the last thing they want to have to do. So I'm just, the trial court obviously found something that was troublesome and something that perhaps he felt inappropriately from the outside influenced the inside of the jury room. So why would we not just defer to that? We give high deference to their decisions, so.
This court defers to the judges on the facts. And on the facts, he held this was based on her prior experience. It's right there in his holding. And on the law, he held that Warger and its progeny and MRE 606B consider prior experiences of a jury that have nothing to do with what was in the jury room, outside influences. Your Honor, the judge made a mistake. And it was a serious mistake of law. And this court does not defer to lower courts that make mistakes of law.
So I just want to clarify, anytime it's a juror who says something, even whether it's inside the jury room or outside, that's not external.
That's not me, Your Honor. That is what MRE 606B says. I have the entire thing written out if you...
Yeah, no, I've got it too, so.
All right.
So, I mean, I guess is that extraneous prejudicial information, though?
Extraneous prejudicial information is outside research. It is a juror going and watching a news show saying that somebody's guilty and then coming back and bringing that into the jury room. Those have been held outside. But any prior experience, anything you walk into the jury room with, anything that's part of you, is internal. And that has been held the same way again and again and again.
Well, what if it's part of her because she looked up the information at some time prior and then said, in my experience, because I used to, I did some research on it at some point before this trial, and I come up with a 70% statistic. Where does the line shift between, well, that's just part of who she is in her experience, and extraneous information?
Well, I guess there's a couple of things here. First is, if the judge wants to ask, or either the party wants to ask during voir dire, whether or not anybody has ever had, learned anything about the statistics of stuff like that, they can. But once somebody comes into the jury room, they're a full person. All right? We do not delve into the past of every person on there. And Warger is actually pretty clear on that even if somebody lies on voir dire, the 606B requirements remain. And there's no testimony about that later on. Not from a juror. You can get it from outside sources, you can get it from different sources, but the jurors are incompetent to impeach their own verdict. If there are no more questions, then I'm going to do what the court was initially going to ask me to do, which is be quiet for the rest of this.
Thank you,
You
Greg.
didn't do a very good job because you talked all the way until 2 minutes and 40 seconds.
I
we
am
had
so
questions.
sorry.
You did a very good job, and you had questions, and we had questions for you. So thank you very much.
Thank you very much. It was
did a
very
great job.
enjoyable to be back in front of you all again.
Thank you.
Have a good day.